This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today I'd like to speak about abuse of the Americans with Disabilities Act, why no good deed goes unpunished, and why that abuse has made a new market for insurers to protect small businesses and small property owners. The Americans with Disabilities Act, the ADA, was signed into law by President George H.W. Bush on July 26, 1990, with the good intentions of helping people with disabilities. It is a federal civil rights law that prohibits discrimination against people with disabilities in everyday activities. The ADA guarantees that people with disabilities have the same opportunities as everyone else to enjoy employment opportunities, purchase goods and services, and participate in state and local government programs. The stated goal of the ADA was to eliminate discrimination against individuals with disabilities. A major source of discrimination suffered by disabled individuals is the inability to gain access to public accommodations such as restaurants, hotels, movie theaters, gas stations, and the facilities of other small businesses. The intent of the statute was to ascertain that businesses that want to comply with the law should be able to do so without undue cost, delay, or uncertainty. Although the statute was full of good intentions, the law of unintended consequences took hold, and those good intentions were taken advantage of by unscrupulous people and their lawyers. Lawsuits proliferated by persons who claimed to be disabled or simply took the position that they were advocates for the disabled. In truth, the ADA advocates and their lawyers litigated under the ADA with the sole purpose of making money. Most had no intention or concern about the needs of those with disabilities. They took advantage of the provisions of the statute that allow individuals to enforce the accessibility requirements to bring a private right of action against individual businesses and property owners. The important reform in advancing equal access for the disabled has been used by some bad actors for monetary gain more than disability advocacy and threatens the small business economy in some states. The people abused by these bad actors are the owners of small businesses and owners and tenants of small retail establishments, like the owners of bodegas, liquor stores, chiropractors, healthcare providers, and lessors. Under the private right of action allowed by the ADA, an aggrieved party can seek injunctive relief remedying the violation and attorney's fees and costs. Monetary damages are not available to private parties seeking to enforce the requirements of the ADA. By providing differing remedies for private and public enforcement, revealed to abusers a method to profit from the underlying intent of Congress to prevent private plaintiffs from recovering monetary relief under the ADA. Although the ADA sets its intent clearly, small business owners have found they are added to the growing evidence of abuse of the private remedies provided by the ADA, whereas a small business and small property owner, he or she must either litigate with the ADA advocates or succumb to the abusive lawsuit with a settlement. If they contact a lawyer, they will be advised that they will lose the litigation if there is even a small technical error of compliance, and be required to pay fines and attorney's fees to the advocates and their lawyers. The litigants and their lawyers know this and will offer to settle for a sum close to reasonable so that they can negotiate down to a reasonable amount that is available to the small business owner to pay. The complaints and discovery are all computer-generated by the advocate's lawyers, with only the names of the plaintiffs, defendants, and non-compliant part of the property changed. The litigation expense for the plaintiff and counsel is minimal, and for the defendant it is excessive. Small business people don't have the funds necessary to protect themselves from an action legally filed under the ADA and concurrently pay to bring the property into compliance. Agreeing to an offer of settlement is the only choice available to a small business owner because no liability policy provides coverage for the defense or indemnity of a suit brought under the ADA. In a case with which I am familiar, a law firm specializing in filing ADA lawsuits and nothing else sued a small business owner allegedly on behalf of a person claiming disabilities, who met with the receptionist, made an appointment to which she never appeared. Shortly after the scheduled appointment, the plaintiff filed and served an ADA lawsuit claiming that the doorbell to the business was mounted 60 inches above ground rather than the 40 inches required for the use of a person in a wheelchair, a technical violation of the ADA. In the 30 years since the building was constructed and acquired by its owner and leased by its tenant, there were no complaints of the inability to use the doorbell. Regardless, the suit was filed and served, and defense counsel was required to be retained to avoid default at the expense of the owner and the tenant from their limited private funds. Insurance companies, when presented with a claim, clearly denied the claim because there was no claim of property damage, bodily injury, or personal injury, the perils insured against by most liability insurance policies. The abuse of the ADA started with its enactment. The abuse of the ADA is well known to federal district court and state judges who see the same plaintiffs over and over again. There is nothing the judges can do because the clear language of the ADA statutes require that they fulfill the requirements of the statute. Attempts have been made to curb the abuse. For example, in 2006, the Hastings Women's Law Journal published an article entitled "Private Enforcement of the Americans with Disabilities Act via Serial Litigation, Abusive or Commendable," by Carrie Becker, then a J.D. candidate. The cases Ms. Becker described were identical and highly similar to the suit I became aware of, and whose defendants found themselves to be one of a multitude of ADA lawsuits filed across the country, and that the minor abuses claimed would cost thousands of dollars to cure, plus the fees of lawyers who brought the suit and the fees of counsel retained to defend the small business owner, plus fines. Since 2006, ADA lawsuit abuse continued to be prolific throughout the nation. Profitability of ADA litigation has given rise to what courts have described as a cottage industry that has little or nothing to do with assisting people with disabilities. Ms. Becker noted that, for example, a single law firm in Philadelphia filed hundreds of lawsuits on behalf of two disabled men, reaping thousands in attorney's fees. Adding to the burden, small businesses are forced to comply not only with the federal standards outlined in the ADA, but also with any state, county, or city-specific regulations. With so many different regulations to follow, it's not surprising that many, if not most, buildings constructed before 1990 are out of compliance. Compounding the problem is the fact that the regulations differ substantially across the country. For example, California's Title 24 regulations require that curb ramps have a 1/2-inch lip at the bottom, beveled at a 45-degree angle, whereas the ADA requires a flush transition at the bottom of the ramp. total compliance with both state and federal regulations becomes impossible. It becomes obvious that the intent of almost all the parties filing suits on behalf of people with disabilities are really designed to bring about a cash settlement. For example, although the property owner cured the deficiency with the placement of a new $5 doorbell, the demand to settle the lawsuit before discovery, adding lawyers' fees, was $15,000. In addition, a check of court records indicated that the plaintiff who sued the small business had already filed multiple ADA lawsuits. One explanation for many people's distaste for the enforcement of the ADA via serial litigation is that plaintiffs and their attorneys stand to financially gain from each of the suits they file and often fail to make the property ADA compliant. Common examples of ADA lawsuits may include when individuals visit several business establishments with the intent to identify ADA violations, which may include the lack of handicapped parking spaces or the lack of wheelchair ramps, and then suing the business for the violation, although the plaintiff was not injured or even inconvenienced. In certain instances, the individual may drive by the establishment and search for violations in the parking lot or outside the business and never actually enter the establishment or attempt to conduct any business there. These individuals can target several businesses at once, often with the intent to win a large sum of money from the businesses for their claimed lack of compliance. As the Los Angeles Times reported in November of 2018, about 10,000 ADA lawsuits were filed in the first 6 months of that year. Businesses are able to handle the cost of upgrades to ensure access. The lawyers that file the ADA lawsuits demand huge payouts. The law then lets them do so with first giving the business owner a chance to fix the lack of availability of a compliant property. For example, according to the Orange County Register, a newspaper in Orange County, California, one Orange County law firm filed 335 ADA cases in that year, including 36 for a visually impaired Montana woman. The Register concluded this isn't about access, it's simple extortion. What the Register did not report was that the extortion is perfectly legal as a result of the ADA statute. In some cases, the lawsuits are collected from the comfort of the attorney's car or even couch, driving by handicapped parking spots to access violations, or using Google Earth to find motels without accessible pool lifts for the disabled. Lawsuits aiming to bring about compliance with an important equal rights law like the ADA are important in advancing the cause. Some of the serial litigators are doing more to rake in damages than increase accessibility, as many states have statutes that go beyond the federal bill and offer individual lawsuit filers cash payments as well as attorney expenses. The incentives to file a lawsuit shift from accessibility and ADA compliance to cash recovery. In California, in addition to having both sides' legal fees covered by a defendant, a plaintiff may recover a fine of a minimum of $4,000 per ADA violation, and the plaintiff is not required to offer a grace period for the violation to be rectified. ADA regulations are poorly dealt with by the nearly 30 million small businesses in the United States. Small businesses often lack the expertise, capital, and legal support to understand and adhere to the regulations. If a business owner's first notice of noncompliance with the law is a lawsuit, The system is askew, and the small business person is not equipped nor able to fund defense of the lawsuit. Sadly, a few attorneys, sometimes called the ADA trolls, realize that ADA can be a profit center by simply filing cases that on the surface have merit. But instead of pursuing these cases to a conclusion, the trolls offer to go away in exchange for a financial payoff. The trolls are especially active in California and New York, where state laws permit private individuals to recover money damages. For years, most of the ADA troll cases involve people in wheelchairs suing over physical or architectural accessibility. Suits would be filed, and the attorneys would then demand a certain amount of money to simply go away. These are not frivolous suits in the sense that they have no merit. What sets these lawsuits apart is that they are filed with such enormous volume that the attorneys involved could not possibly represent the plaintiff properly in any one of them. The critical element of the troll lawyer's business plan is volume. The attorneys have to file a lot of cases, and they do. One pioneer in this area was a wheelchair-bound California plaintiff whose attorney filed some 400 lawsuits claiming that he confronted virtually identical barriers to access at different businesses, mostly restaurants. These became referred to as drive-by cases because there was little or no proof that the named plaintiff had ever actually visited the businesses in question. Although only one of these cases ever actually went to trial, his attorney made an estimated $10 million, and it was not clear how many of the businesses actually fixed the supposed problems. A website, adaabuse.com, reports mega ADA suit filers, one of whom was so egregious he was disbarred. Although there have been attempts to modify the ADA to avoid these abuses, the statute remains unchanged. Since no insurance policy provides coverage for an ADA suit, because there is no claim of bodily injury, property damage, or personal injury, liability insurance like that provided by a commercial general liability policy or a business owner's policy will never provide a defense or indemnity to an insured for lack of covered claimed injuries. Since an ADA suit neither makes a claim for property damage or bodily injury, but only seeks an injunction requiring compliance and attorney's fees, there's no coverage under a CGL or a BOP, leaving the small business owner to defend and negotiate a settlement with the troll based upon his limited or her limited capital. It seems to me, and in my opinion, ADA will not be changed to protect against ADA abuse. Every small business in a facility built before 1990 or without concern for ADA requirements, like most, is a potential defendant in an ADA suit and will be held to uninsured ransom. No current liability policy I know of or common liability provides coverage for an ADA suit. As a result, a small business owner, lessor or lessee that protects with insurance will find their assets naked to the ADA trolls. The small business owner will need to retain counsel, defend the suit, pay the legal extortion, or face a major judgment, or file bankruptcy and go out of business. The ADA has created a large market for the liability insurance business, and those insurers, by use of a simple endorsement to a CGL or a BOP, can create coverage to protect the small business owner and work to defeat the ADA trolls. I propose the following endorsement be issued. Quote, "This endorsement changes the policy. Please read it carefully. It is hereby understood and agreed the policy is revised to read as follows from the date of inception to the date of expiration stated in the declarations. This is an Americans with Disabilities Act endorsement and provides special limits of liability applying to this endorsement. The limit is $25,000 for the cost to make your property comply with the requirements of the ADA to conform to the accessibility required by the ADA and alleged to be in violation of the ADA by a civil suit naming you as a defendant. The insuring agreement follows. We agree to pay whatever is required by counsel of our choice to defend and indemnify you if you are sued for violation of the Americans with Disabilities Act that are claimed to have prevented a person with a disability or disabilities that the plaintiff or plaintiffs claim prevented the plaintiff and or others similarly situated to access and use your premises because they are not in compliance with ADA standards as it relates to users with disabilities like the person suing as plaintiff. We also agree to indemnify you of the cost to bring your property in compliance with the ADA and correct the errors or deficiencies alleged in the suit brought against you up to the limits of liability. All other terms and conditions remain the same." Close quote. Every owner of a small commercial building, apartment house, rental property, or operating a small business that invites the public will or should rush to buy insurance to protect against that risk. The prudent insurer with a staff of lawyers, adjusters, and contractors will rush to pay extra to add the coverage to their liability insurance policies. It's a huge market. This video was adapted from my blog, Zelma on Insurance, which is available to anyone who clicks on the link and the URL zelma.com/blog. It is also subject to being subscribed to for free, and you will learn of all blog postings, usually 5 or 6 a week, where there is already more than 4,500 blog postings. You can also subscribe to the videos at rumble.com and at youtube.com, and I'd appreciate it if you click on the like buttons on either video format that you view. If you found this video to be useful to you, please tell your friends and colleagues so that they can also subscribe to the blog and or the videos. And if you found these videos to be really useful, you might consider getting further detail by subscribing to my Substack publications or my locals community for a very small fee. Thank you for your attention.